And as we get started, I just want to take a moment and really reiterate what Costa said about the importance of the Italian Judicial College Decentralized Training Section of Naples participation with us, not only in this series of roundtables that, as Costa described, are examining the role of advisors, tax advisors, but more broadly in their engagement in this work of trying to understand and assess the impact of the role of tax advisors, whether it's in facilitating compliance in questionable areas, or as we're going to be spending our time today, in illegal conduct. And really their participation and their engagement, I think, shows the collective importance we all see on these issues, and we're very grateful to have them with us today. I would like at this moment to give the floor to the judge responsible for the decentralized training of the Italian Judicial College in Naples, Barbara Grasso, for some brief welcoming remarks.
I would like to thank you for granting me the opportunity to deliver a brief welcome as the representative of the Court of Naples section of Italian School of the Judiciary. I would like to express my gratitude to all the organizers for allowing us to participate in this international event that focuses on the various degrees through which professionals may be involved in criminal activities related to tax crimes. As a member of the judiciary, we recognize the intricate nature of financial systems and the dense web of regulation that govern them. We understand that tax evaders cannot act through this complexity without the indispensable guidance of skilled professional who possesses the expertise to steer them. Additionally, we acknowledge the difficulties the legal system encounters when attempting to confront the activities of these facilitators. The implications of these matters are profound, touching on critical legal and societal concerns. They bear significant weight for the justice system and the broader society, despite their infrequent, I have to say, discussion and the rarity with which they are examined under the scrutiny of the courts. These issues warrant our focused attention and a concerted effort to address the challenges they present. Your ongoing research, which analyzes these phenomena on a global scale and through a comparative lens, has great significance and potential impact on society and public execution. For this reason, we thank you in a special way. It raises public awareness of these issues, enhances technical understanding for legal practitioners, including the members of the judiciary, and allow us to focus on new legal questions and explore what could be innovative solutions. The significance of today's event is also connected to the approach aimed at revealing the intricate links between tax offenses and various forms of criminality, such as money laundering, as we have already heard, corruptions, and organized crime. Unethical and illicit activities of professionals can play a role in this area of criminality, creating distortions in functioning of tax administration and in the efforts to counter crime. In this regard, the insight form of the article Beyond Bribery, exploring the intimate interconnections between corruption and tax crimes that Professor Ring and Professor Grasso have written, have been instrumental in deepening our grasp of the complex interplays between corrupt activities and tax offenses. Therefore, we are thrilled today to be here with all of you and to include this event in the training activities provided by our section of the Italian School of the Judiciary. We will closely follow the debates and discussions, and we are confident that through today's exchanges, we will gain further insight into the subject addressed in this International Roundtable. Thanks again.
Thank you very much, Judge Grasso. And we're just delighted to have you and your colleagues with us today. So at this point, I'd like to introduce our panelists who will be joining us through our 2 sessions. And so I'm just going to run, because we want to spend our time hearing from them directly, I'm just going to briefly run through their names and their identifying titles. But I encourage you, if you'd like to find out more about our panelists today, you can visit the Corporate Crime Observatory website, and you'll find that link posted in a moment. And you can learn more about our panelists. So briefly, and I think pretty much alphabetical order, Teja Bedinsky, Deputy Municipal State Attorney from Zagreb, Croatia. Enrique de Salvador Lopez, Federal Prosecutor at the Federal Prosecutor's Office in Brazil. Calajero Ferreira, European Delegate Prosecutor, the EPPO, the Prosecutor's Office of Palermo, Italy. Hassan Habib, Senior Analyst in AML Operations Governance, Canada. Roel Kerkhoffs, Public Prosecutor at the Dutch Prosecution Department for fraud cases. Sasha Lehman, also at the Public Prosecutor at the Dutch Prosecution Department for fraud cases. Irina Marasovic, Deputy Municipal State Attorney, Zagreb, Croatia. Vasilios Petropoulos, Assistant Professor of Criminal Law and Procedure, University of Athens. Emanuele Piano, Investigative Journalist and Director of www.invisibledog.com. Mate Rosca, Investigative Journalist, Owner and Publisher of Reporter.London. Gianfranco Scarfo, Deputy Chief Prosecutor, Prosecutor's Office of Benevento, Italy. Bernd Schlenter, Lecturer at the African Tax Institute, University of Pretoria, South Africa. Laureen Snyder, Emeritus Professor of Sociology at Queen's University, Kingston, Canada. Sergio Spadaro, European Delegated Prosecutor, EPPO, Prosecutor's Office of Milan, Italy. Brandon Sullivan, Independent Scholar and Expert in Criminal Justice. Massimiliano Vicenti, Investigator in European Anti-Fraud Office and the European Commission, Brussels. Richard Weber, Partner at Winston & Strawn LLP and former IRS Chief Criminal Investigative Division in the United States. Simon York, Senior Associate Fellow at RUSI and former HMRC Chief Investigative Officer in the UK. And Diane Willman, Deputy Director, Asset Forfeiture Unit, the National Prosecuting Authority, South Africa. So we're delighted to have such a wonderful and quite varied panel in terms of their work and expertise. What we're going to do today is run in 2 sessions with a 10-minute break between the sessions. The first session is going to examine, which we'll start now, examine the role of tax professionals in tax-related crimes, focusing on their failure to prevent client misconduct and their own criminal involvement. We will be discussing how professionals evade legal repercussions while facilitating illegal tax actions. And the session is also going to address the detecting and punishing of culpable individuals and organizations, and look at the legal frameworks, investigative methods, and enforcement tactics that can be employed. And additionally, during this session, we will consider the obstacles faced by professional bodies and legal authorities in addressing these transgressions. So that's our mission for this first session. So to get us started, I thought I would open up with kind of a preliminary question and encourage you to sort of think about who are the most commonly involved practitioners who are actually facilitating or enabling or participating in tax criminal activities. And so, I'm thinking a range of people might include accountants, lawyers, auditors, notaries, financial advisors, so on. But who comes to mind? And specifically ask you, what do you see as their different roles and functions in this sort of what we're describing as the dark area of criminal activity? So just sort of to open it up to whoever might like to get us started thinking about who are the players and what are their different roles? And Sergio, turn to you first.
Thank you, Diana. I apologize for not answering immediately. If I may, I would like to make a few comments, just 2 comments, to the speech of Mr. Rudolph, which I was really, really impressed, if I can. I completely take his point about the importance of the independency of judiciary when we talking about tackling tax crimes and offenses which involved such a large amount of money, of assets. Every time I have the chance to speak about it, I'd like to emphasize this point. And from this point of view, I think Italian system provides a good example of the importance of the independence of the judiciary, and especially the independence of the prosecutor office. This is something that is not always easy to handle when you are in contact with the colleagues of other systems, of other countries. And it's not always easy to deal with it. Having said that, I would like also to break a lance in favor of the prosecutors and judiciaries of Switzerland system. I've been carrying out investigation with them since a very long time, since about 15 or 20 years. And I can witness, I can give evidence that they always gave me a great support also, and especially in tax fraud, tax-related offenses and investigation. Is it true? It is true what Rudolph say about the problems about the bank secrecy, the anti-money legislation in Switzerland. But for my experience, it's something that you can overcome every time you have a good cooperation system, a good mutual legal assistance request, and a good cooperation that allow you to go through all these issues. Thank you.
Thank you. Laureen, did you want to speak to our first question?
Yes, am I unmuted? Okay. Yeah, I wanted to mention that we know a fair bit about the professionals involved here because they have organized since 1991 into a group called the Society of Trust and Estate Professionals, STEP. And that was formed, as Brooke Harrington's superb book on Capital Without Borders tells us, in 1991. And though they don't call themselves specialists in tax evasion, they call themselves specialists in wealth management and estate management. And they will only take clients who are from the very top 1%. So, and there we know that most of them are accountants, lawyers, bankers, with a fair sprinkling of lobbyists who often have more than one role. We also know from Harrington's book something about how they rationalize what they're doing, and as the first presentation showed, how they hide it so well.
Great, thank you. I don't know if anyone else wanted to speak to that, and if not, I'm going to kind of take from that and just kind of move into a little bit more thinking about specific participation. So I was going to invite you to think about the different circumstances in which professionals participate in tax crimes, and what are the features of their involvement. So what are they actually doing? What does it look like? And what's the sort of level of, I'd say, mens rea, right? Is it negligent? Is there real intent? And maybe if you could, where possible, illustrate by cases. I know you come from many jurisdictions, cases that you are seeing. So Simon, I'll start with you.
Hi, no, thanks, Diane. And sort of perhaps picking on the last question and this question and bringing that together a little bit. So in my experience of dealing with tax compliance for 30 years and the tax crime and tax fraud specifically over the last decade, the majority of what I would describe as tax professionals, and I think that would include accountants and all the rest of it, are a real force for good. In spotting potential tax evasion, in preventing it happen, in talking to their clients to ensure it doesn't happen. There are some who are incompetent or they're negligent, which can lead to their clients committing tax evasion, or they're not spotting it, whatever. And then you've got a minority who actively support, sometimes go beyond what they sometimes encourage or promote even others to commit sort of tax crimes of various sorts. And I think that minority are all motivated in some way. Your average accountant, your average tax advisor isn't really all that motivated to get involved in criminal activities. But you've got the sort of offshore centres that were described in the first presentation, where you typically have a blend of professionals there, but they may be selling bespoke schemes that need a range of different professional advice, including tax, but certainly not limited to tax. Then you have some people who will be selling specific schemes. Might focus on one niche area of the tax system, which they believe is vulnerable either to some sort of loophole or avoidance, but it may well border into dishonesty and consequently fraud. And then for some of the very wealthiest people, they may almost have a personal advisor who only supports them, only advises them, or only advises a very, very small number of clients. And of course, they've got a big motivation to keep that client happy. That client is their whole livelihood. So there's a range of different types of scenario, I think, where tax professionals. But I think it is. I know in this webinar we're talking about the dark area, but it's really important, I think, not to label all accountants or all tax advisors, or even the majority, because the vast majority are a huge force for good in preventing this type of thing happening.
Thank you, Simon. And I think that's just a good point particularly for those who might be listening in our audience. The first panel roundtable that we did was in fact really looking at the role of tax professionals as aiding compliance, sort of the really positive role that they can play in the tax system. And then our second two panels looked at sort of a more complicated in-between space. So very much sort of today's conversation fits into a broader framework of thinking about the multiple ways in which tax advisors and those who are supporting it are engaged in what happens in the tax system. So absolutely right. Just today we're sort of looking at, as that you may have described, the less seemly, the more unseemly side of it. But good point. And I encourage those who are interested to go back again to the Corporate Crime Observatory website and see those earlier roundtable discussions. Irene, I'd like to turn to you.
Thank you. I just wanted to say that I agree with Simon. I wanted to mention that when I was taking part of a couple of investigations regarding the criminal offenses of organized crime association and tax evasion within that framework of a criminal association, we noticed that one of the members of that criminal association was always a tax professional. Majorly, it was an accountant, and their role was enabling that organization. And regarding the mens rea, they always had an intention, at least in our case. So thank you.
Thank you. Vasilios.
Yes, thank you very much. So I also agree with the aforementioned, with Simon, with Irina. And if I may add to that, according to my experience from practice, also as a lawyer, in all the cases that I have seen, it's mainly accountants, auditor, and financial advisors, the ones who have the bigger picture, so to say, in order to facilitate tax evasion between multiple jurisdictions. Whereas also perhaps notaries and lawyers might assist them, but according to what I have seen, mainly lawyers do participate in a so-called second stage, and in many times they don't have the full picture. They are just used, for example, in order to establish shell companies and so on. And this is sometimes the case, for example, in Greece with Cypriotic companies from Cyprus. One can establish a Cypriotic company, but the lawyer who does this does not have the full picture. So in this case, I also agree with Irina. It's mainly the accountants and auditors who do have the mens rea, perhaps intent as well, but mainly lawyers could, let's say, assist negligence assist. Thank you.
Thank you. Richard.
Great. Am I unmuted?
Yes, you are.
Awesome. Well, it's good to be here. I want to thank Constantino and the Observatory for inviting me. It's always good to participate in these programs. So I also agree with Simon. I think everybody always agrees with Simon. And I will add that when I was chief of IRS criminal investigation here in the United States, our agency worked very closely with Simon and his agency and the UK more generally. And I will also add that it is really good for government and really bad for criminals when other countries work so well together. And I think that's what you're seeing right now, especially in the tax enforcement world, where you have a host of countries working incredibly well together to fight all sorts of crime, including tax crime, across the globe. With respect to the particular question, one of the areas that I have seen in the last couple of years relates to tax promoters, and those promoters could be attorneys, those promoters could be accountants and other tax professionals in a host of different specific criminal areas. One in particular has been related to COVID. And that's in the US, something that's called the employee refund area, where the promoters are basically enticing victims, taxpayers who are not eligible for this particular employee retention credit related to COVID, but they get a significant percentage of money for getting them into the program, and then completely kind of walk away from them. They do very little in terms of working with them, except to attract them into the system, get them as a victim to apply for a program that they're not really qualified for, and then the IRS goes after them, after the taxpayer for not filing a correct tax return and committing fraud. So it's an area that's really, I think, hundreds and hundreds of millions of dollars in terms of tax loss, and many, many impacted taxpayers in the U.S.
Are you able to unmute, Gianfranco?
Okay.
There we go. Perfect.
Hi, everybody. I see a lot of friends over here. And then from the Italian perspective, I think that one of the main actors are the accountants. The most prominent actors in this kind of schemes. I remember once we did an investigation concerning tax evasions, and we found out that there was a Neapolitan accountant who was the actual representative of hundreds of companies. And in fact, all those companies were just stamps, just like these, that were held in his office, by which all these companies were issuing fake invoices in order to let other companies reduce tax incomes, and so as to reduce taxation. And then it looks incredible as one can create shell companies just like that, and that is the main one of the main issues we find. We are not looking after negligent conduct. We are looking after malicious conduct. If we were to look after negligent conduct, it would be quite harder task than the one it is now. So then we can talk later about lawyers, which are on a higher level of sophisticness, thinking about that. But the main actors, in our view, are accountants.
Thank you very much. And I just wanted to take a moment and just point out that Costa has included in the chat function links to the other panels that roundtable sessions that I referenced when I said that we had explored sort of the roles of tax advisors in a very positive way, in a more complicated way, preceding today's session, looking at really that space where, in fact, they really are aiding in criminal conduct. So I encourage you to take a look at those links and save them. Bernd, I would like to come to you.
Thank you, Diane. Hello, everybody. Certainly in South Africa, we had a bout of state capture. And the odd thing was, there were not really lawyers involved. What happened was, because of state capture, the prosecuting authority was really captured, which led to no prosecutions against some people implicated in state capture, which is pretty different from what one would think about. What we've seen, though, is particularly with tax evasion and tax avoidance, is the use of offshore centers where banks are typically involved, and also the use of foundations and trust, whereby people attempt to shift their profits or assets offshore. So pretty much, I think, the same as the other jurisdictions. Thank you, Diane.
And Enrique, and then we'll move to our next question.
Okay, thank you. Just to give the Brazilian perspective here, just like Basileo said, the heavy burden tasks of tax evasions are actually made by accountants, and the lawyers just participate in a very small niche tasks of opening accounts in other places, in other countries. So if you really want to make some change here, we need to focus more on those who really make the things, the crimes happen, which are the accountants.
Thank you. Sort of moving forward with this picture of professionals being involved in various ways, I want to sort of invite you to think a little bit and offer some observations on the ways in which these professionals avoid detection. So to the extent we have these professionals engaging, supporting tax crimes, are there specific strategies that they are using to evade legal accountability? Does the attorney-client privilege play a role that you're seeing? So how is it that they're sort of staying out of the sort of space of being detected themselves? And Laureen, I'll start off with you.
Okay. Yeah. As one of the academics, I'm not at the sharp end, so I don't have case studies. But I think we know that in a lot of cases, tax professionals or tax evaders, avoiders, don't need to avoid detection. I mean, there was an excellent article in the New York Times in 2021 showing how the big four accounting firms all have deals with, well, they have a revolving door syndrome with the four big accountancy firms, so that the accountants are part of writing the rules when they're in the Treasury Department, and then they're part of evading them or advising their clients on how to evade them. when they are back in the accounting firms. Thanks.
Thank you. Bernd?
Yes, certainly what we've seen is, and there's a good case on this, is the Steinhoff case. South African company basically overstating its assets, doing business in Germany, other parts of the world. So there was an investigation into the company's financials done by PwC, and the media got hold of the allegations, and they wanted to, publish some of that. And because they knew that the company also had the report from PwC, they tried to get access to that via the promotion of access to information legislation, which the court granted because from the case it was quite clear that the Steinhoff, the company, basically tried to insert the legal privilege as a way of not disclosing the findings of the audit report of PwC. So that's pretty much what we've seen here, and it's quite a recent case as well.
Sergio.
I would like to support Bern's view. Also, in my experience, the abuse of, in my view, of legal privilege is something that harmed our investigation, our attempt to get evidence from companies. That's why also having in mind what you already said about the role of accountants, they're very important, of course. But I think I say don't undervalue the role of lawyers, especially internal lawyers within the company. Why? Because every time they act as a lawyer or as an employee, they can or they try to raise their legal privilege. Every document they touch, every time they sign with LP on an email of every kind of document, of chat, you cannot even see the documents. Maybe this is a use of legal privilege. I call it abuse of legal privilege, but maybe a better word would be abuse of process, because we are not always able to address such issues between a court in a fast way, in an effective way. Thank you.
Thank you. Simon.
Yeah, I mean, I guess the first thing to say, it's not always clear whether an accountant or a lawyer is sort of deliberately enabling a client to commit crime. You know, sometimes there might be, or it might be that they've just given advice and then the client has gone off and done something different to that, which has turned it into some sort of tax crime. But if the authorities, enforcement bodies, the tax administrations of various countries can prove criminal activity, evasion, fraud, then advisors face, well, at least the same sort of sanctions, civil sanctions, like penalties, or criminal sanctions, like custodial prison sentences, as do the individuals who are committing the fraud. So if someone's criminally facilitating something or criminally advising, then they face all the same of that. In terms of how they get around it, one of the trends I think we've seen in the UK over recent years is particularly people who are promoting what they might describe as some sort of avoidance scheme, but is so clearly that it doesn't work. It's almost fraud, really, or it probably is fraud in some situations. They base themselves offshore, and it's quite difficult to get hold of those individuals to bring sort of sanctions to bear on them if they and their firms and their assets and everything else are outside the UK, particularly in a jurisdiction that's perhaps difficult to apply those sort of rules to.
Thank you. Rudolph, had you had your hand up? I wasn't sure. I saw it pop up and down. Oh, you're on mute if you're talking.
I obviously talked about offshore lawyers, which basically I meant lawyers within Switzerland working for offshore lawyers in the Caymans or whatever. But we have to think about how does it function. For instance, in client meetings, I learned that you explain to the client that he has a problem money-wise, tax-wise, and the client he thinks he pays too much taxes. We as a banker, we do have a solution, but it's a complex issue because I'm talking about ultra high net worth individuals or the high net worth individuals. It's a complex issue. We need to have a Swiss lawyer involved who sets up the structure. So it's the bankers as such, because the banker knows the clients in and out. He knows if he has a girlfriend or whatever. He's a very personal relationship, and then he makes the connection to the lawyer in Switzerland. The Swiss lawyer makes the connection to the Maples and Calder in the Cayman Islands. That's the procedure now. They're talking about optimizing the tax matters, which is fair to say that's not a crime, but I don't think that the client really knows what he is doing. He is happy about having to pay less taxes than the other year.
Thank you. Brandon?
Yes, hi, can you hear me okay?
Yes.
Great, thank you for having me. I really appreciate a chance to be able to be here. The question was about how to avoid detection, and most of the cases, you don't really have to avoid detection. You just hide in plain sight, and you just kind of carry on and do the activities that you want to do to try to save as much money as you can. And it's aided by a number of things, except for the most egregious cases, which are pretty obvious and detectable that I can talk about later. It's the ones that draw attention to themselves. Most of them don't really draw attention to themselves, and they're aided by incomplete and muddy laws where can get advice from people who don't really understand what the laws are, don't care to understand it, and they have a lot of money to be able to, this is the high wealthy taxpayers now, to be able to try to draw out cases when they may be detected to the point where the government might just give up, or in a lot of cases they don't really, the auditors are inexperienced and don't really have the expertise or the time or the resources to be able to pursue those cases fully out, and then they just kind of peter off. And the more complicated you can make it, the less likely it's going to be resulting in any kind of negative penalty for the person committing the crime, because they are just able to say, just deflect their responsibilities, or just make people think that that's fine, or make them give up.
Thank you, Brandon. Calahero?
Can you hear me? Yes, I think we have to distinguish two different perspectives. One is when the professional, the accountant, the lawyers help someone to pay less taxes or to avoid the taxation, a certain level of taxation. But I think this is not the case we're dealing with, we are dealing with. Usually we see that in many tax crime, especially the most complex, let's think about carousel fraud, the system to evade the VAT, the system to create a structured situation for the complete evasion of taxes, completion of payment taxes that require a special competence. The role of the accountant or the role of the financial lawyers is material, is crucial for the commission of the crime, because we are dealing with complex structure that require legal, high-level legal knowledge of different legal system, both of tax system, but also of a criminal system or a procedural criminal procedural system in different states. And in this case, the role of the professional is really strategic for the commission of the crime. Let's think about, I know that there are many sessions about that also later on, but especially in the organized crime case, the role when we dealing with financial crimes is necessary a technical support, a strategic support given by this kind of professionals that have the competence. So I think it's, and for us as a prosecutor, I'm a prosecutor and I'm working as Sergio, like a HEPO prosecutor, a prosecutor with a specialization on tax crime or financial crimes. We always start exactly from the analysis of the behavior of the professional to reach the final evidence, to get the final evidence for the commission of crime.
Thank you. Mate?
Thank you. Can you hear me?
Yes.
Right. So I just wanted to make a point that there's an interesting role for technology in tax avoidance these days as well, because there's increasing promotion of jurisdiction hopping in different services that require tax. So, for example, if you gamble and if you gamble in the UK, you have to pay, or rather, the company has to pay 20% on your bets. The UK applies this tax surcharge. So increasingly, I found in a story I covered a while ago that gambling companies are encouraging people to use VPN in the UK, so that VPN is a software that you put on your computer and it spoofs your location, so it makes the computer think that you were in another country. So that helps the betting firms cook their books, essentially, to suggest they don't even have to pay these amounts in the UK because the bet happened in another country. So it's not just professionals and accountants and lawyers anymore, but computer engineers are getting in on the tax avoidance and tax evasion game. So yeah, there's that. I just wanted to point that out. Thank you.
Thank you.
Well, I would like to say that in Croatia, we have more and more cases which involves a person who are opening more and more legal entities, 2, 3 or more, and then just issuing fictitious invoices about some use that sorry, I've lost my words. Some service they do not actually use, and we have more MLAs towards third countries and international European investigation orders issuing about detection those persons, because sometimes it is hard to detect a director of legal entities, and we have mainly reached with good communication with European countries and third countries. But however, I think that our legal systems sometimes work really slow detecting those persons. Thank you.
Thank you, Taya. So now I think, Emanuele, I'll come to you and give Royal a little bit more time.
All right, thanks for this. I just wanted to sort of throw in a question myself, because I mean, I'm facing a lot of, experts, and I'm just an investigative journalist. But sometimes I see that the loopholes, there's two things after listening to you all, I was wondering about. The first one is, why do we need to resort to fraud and abuse on tax evasion if you're legal entities, when there are so many legal ways of actually paying less taxes, or, striking a deal with the government of Ireland to literally pay no taxes, or, legally move my activities offshore? So why do I have to resort to fraud and illegal activities when I'm not carrying out an illegal activity myself? Of course, if I'm the mafia or an organized crime group, my proceeds are illegal, hence why I am already in the dark. Secondly, a lot of loopholes are already present within your jurisdictions, and I'm specifically thinking about the UK. We cared about, we did our investigation for Al Jazeera on money laundering. And it just so happened that we met a series of individuals who had companies opened under their names in the UK, namely, unbeknownst to them, using their personal data. But the fact that you can basically file an online form to open a company without ever being present or being present in front of an official, be it a notary, be it a company registry guy, or anyone, just makes it very simple for any professional to exploit your personal data for opening up entities that then can operate legally or illegally, but that doesn't really make a difference if you're just operating under my name and have no clue you're doing that. So it's sort of this question mark that leaves it open for, you know, legal loopholes that professionals can exploit, which are, you know, present within the actual legal system. So we don't have to resort to illegal activities if it's legally possible to do stuff like that.
Yeah, no, thank you, Manuela, because I think that's an interesting point and really was why we separated out the two conversations. There is a rather significant space of a wide range of whether we think of it as intentional loopholes, lobbied for, you know, regimes. I think that reflects the prior comment about revolving doors that Laureen mentioned, being in and out of government drafting regulations. There's that, which raises its own ethical and structural concerns. But then we've moved today to just actual crime. It may be a smaller subset, but it's real crime. And that's an interesting question. If there's so much flexibility in the tax system and so many opportunities to engage in avoidance, when and why are we seeing taxpayers move to pure crime and tax crime, tax evasion outside of already criminal activities, which we'll talk a little bit more in our second round, but a really interesting question. Rael, were you able to get your system back on?
But what I would like to add to what Matej was saying is that, yes, I recognize that accountants and tax advisors played quite an important role in tax fraud schemes in the past. But what I see in the most recent years is that we should not underestimate the taxpayer themselves. They are quite well informed about what's possible in the world, what they can get and buy offshore. And what I see is that they first address tax advisors or accountants in the Netherlands, at least, with, let's say, a small piece of the whole picture. And then the accountant or the tax advisor steps in, doesn't get the full picture again, and then gets dragged into the fraud scheme. And the problem is then, down the road, that the professional is not critical enough, doesn't ask enough questions anymore, maybe at some point faces outstanding invoices, so he's anxious to stop his services, and then more or less gets part of the fraudulent scheme. And then, if later on the government, the IRS, the Dutch Revenue Service, or the prosecution office gets aware of the fraud scheme, then they don't feel free again to, let's say, present the real facts, but they keep on moving in their own storytelling. And that's, I think, the role we see in the Netherlands more and more. Professionals dragged into the scheme and not being critical enough down the road, and therefore becoming part of it in the end.
Thank you. Rudolph, I think you had your hand up maybe earlier, so I want to make sure I came back around and gave you a chance.
Yes, I have an issue about, let's say, know your client and source of clients and what's really happening. Is it legal or is it legitimate? I think the approach to look at it, if it's illegal or legal, yeah, we have to take another approach. I think in a structure or whatever a client does, is the question is, what is the purpose of it? And once you understand the purpose of the structure, the purpose even on payments during that structure is alive, then you can say in which direction it goes, if it's legal or illegal. So we have more to focus on the purpose than on the know your client or source of funds, in my view.
Thank you. Thanks. I want to now turn our attention to think a little bit more about not just the individual advisors, and it's been a little bit woven into some of the remarks so far, but to think a little bit about the entity level, sort of the corporate involvement. And so to ask it sort of the question of to what degree we see consulting firms engaged in illegal tax activity, so whether it's facilitating or sort of, enabling, and also we can imagine law firms, accounting firms, sort of how are they participating as entities in facilitating tax crime? And I think relatedly, how are they, back to this question, how are they avoiding legal liability, legal accountability? So thinking about it more from a firm level and not necessarily solely just individual actors within firms. Simon first.
Yeah, I mean, I was originally just going to come back on that last point, but I will pick this up briefly as well while I'm speaking. So just that last point about looking at the purpose first, which I sort of understand, but I don't really agree with. The purpose of all of these things really is to pay less tax, but paying less tax isn't necessarily wrong, or it can just be structuring your affairs in a very sensible way. It can be avoidance that a tax authority would want to really challenge and take through the courts or whatever. There may be penalties that apply to that. There may not be. But if it's going to be tax evasion or tax crime, and I think this is a really important point that gets lost, certainly in the UK, and I think it's the same in most places in the world, there's got to be dishonesty. It's got to be deliberately dishonest. And that's what brings the criminal law into play. If it's just someone saying, this is what I'm doing and being honest about what they're doing, but saying that reduces my tax bill by 50%, prove me wrong or take me to court or whatever, then that doesn't bring into play all those sort of criminal sanctions. So just quickly on your point there, I think our experience in the UK is that the involvement in the big firms, the big consulting, big accountancy firms, in promoting avoidance schemes, which is mainly where they were very rarely involved. In our experience, were very rarely involved directly in evasion and fraud. But they did at one point get involved quite a lot in quite aggressive avoidance. That has dramatically dropped away. And most of the big firms particularly work very hard to be squeaky clean. They don't have much, they don't need to get involved in this sort of stuff as really. So that would be my experience, is that the very biggest firms are significantly better in this regard than they were, let's say, 10, 15 years ago.
Thank you. Vasilios.
Yes. Well, once again, I agree with what Simon just said as a conclusion. And from my point of view, the cases that I have seen in this section are related with, let's say, the so-called intergroup transactions, where companies that have affiliate companies in several other jurisdictions tend to be dishonest, as Simon said, and they are creating laws in less privileged jurisdictions, and they're creating their incomes in the jurisdictions when the tax percentage is more in their favor. And in these cases, I have seen the assistance of these tax consulting firms, which I also agree with Simon, it's not the biggest ones that usually do assist. And as a matter of precaution, what they do in order not to be directly involved, they mainly use, let's say, reports not directly associated to a specific client. But these are reports that they are directed mainly to clients, although it's not a report for a specific client. So that's from my point of view.
Thank you. Sasha.
Okay, then it's fine. I think in the Netherlands we see more or less the same. The big four and the big advisor firms, yeah, they care about their reputation, so they are really careful in what they are advising. But we do see some individual partners who we prosecute. And sometimes that's because of the money they want to make with their deals. They are under pressure to make enough revenues, but that's not on the level of the firm, but more for the individual partners. Thank you.
You know, I thought maybe now that we're sort of thinking a little bit about, oh, Sergio, do you want to add something in here?
Yes, about the involvement of tax firms, and especially the most important, the so-called Big Four. It's true, they have to save their reputation. They are very careful in what they did, in the reports that are full of disclaimers, and they need to save their reputation. But that's why but they are still actually involved in setting up the structure of the transactions, the companies abroad, the offshore company, and so on. Then it depends on the crimes, of course. It's difficult for prosecutors to prosecute them, to go over them, assuming their involvement, because it's very hard to get the evidence of their active involvement. And even when there is something wrong that is in the paper, it's not always easy to get the conviction. There was a recent case of our Supreme Court of Cassation in Italy, which stated that which found not guilty one of the so-called Big Four, having issued a positive opinion on a false financial statement. Because even in this case, the board of directors, of managers, would have the possibility, the chance to approve, even with a contrary opinion. So they didn't find a positive action of the advisors. It's a hard life.
Okay.
Okay, I would like to go back to Simon's point and to talk about a little bit about dishonesty. In my opinion, sometimes it's not. I'm sorry. It's not so obvious when we have dishonesty or not. Sometimes the companies just misrepresent the things that are really happening, and they put the information out of reach of justice and of tax authorities. And there's not per se something false or fraudulent, but something that is not transparent, that's not truthful. So can we say that the use of these vehicles that happens to lack of transparency, is this dishonesty? I don't know. Let me give you an example. You have to file a tax filing, and you do it so using an offshore account or offshore entity, and you don't really know which person is the beneficial owner of that entity. And but that information is in some way available to tax administration if they do an MLAT or maybe some sort of other way. But that other way is so difficult to do that in reality, you don't have the information. So is that dishonesty? Is that in reality the lack of information? I should be truthful, but here in this case, I'm not being truthful. Is that dishonesty?
Thank you. So I have Brandon next and Mate.
I just like to build on that because it depends on what we're defining as crime and what we're referring to as crime. Because in terms of like the major firms, if a lot of the things that might have been considered crimes at one time have been slowly eroded and redefined as to being non-criminal and end up being dealt with in a civil or administrative manner. And in terms of what crimes they may be committing, we don't really know. There's a lot of information that they hold secret and that we just don't have access to. And whenever there is an irregularity, because of the decreased desire to actually deal with major firms in a criminal sense and trying to deal with them in terms of encouraging voluntary compliance and relying on things like deferred prosecution agreements, for example, if there are irregularities, it's more likely to be dealt with outside of the criminal justice system as opposed to actually issuing criminal charges. So it's much of it, it's a question that we can't really answer very well in terms of what kind of crimes they may be committing, because they may be redefined not as crimes, or we just don't have the access to a lot of the information. We need to make that assessment.
Thank you. Mate, then Gianfranco.
Thank you. This is not directly related to tax. It's a point about honesty that I would like to make from a tweet by Dan McCrum that he posted the other day about lawyers and judges and honesty. Dan is the FT journalist who covered Wirecard and arguably exposed Wirecard as a fraud before anyone else knew about it. So he pointed out that in one case in London where an entity from Mauritius connected to Wirecard was accused of fraud, this entity was unknown with unknown beneficial owners. This company hired very high-powered lawyers in London, and the judge dismissed the claim, which partly included this company, saying that, you know, actually this high-powered law firm in London must have done its due diligence. So I tend to believe that this company is above board and not fraudulent, although I can't say who owns this company. And of course, later on, it turned out that things were a lot more complex. So you know, just having a big legal name attached to you, which you pay for, obviously can help your reputation quite a lot. So I suppose lawyers who work for these big multinational law firms should really be mindful of who's using their good name and what for. Yeah.
Thank you. Yeah, Gianfranco, you're up.
Speaking of firms, I can tell you something about firms in Italy where you can find lawyers, accountants, engineers, business accountants, so business services. And they are used according to our investigation, to make a particular tax fraud. Simon talked about earlier on about selling schemes, where we find out that these firms, they actually sell fraud schemes to companies. It's not companies who are looking for fraud. It's these firms that look for clients for frauds. And what they do is using a particular legislation tool in taxes. Our legislation in later years provided a lot of tax compensation provided by creating a tax credit bonus. What happens is that I am a company. If I do research, if I do development, these kind of schemes, I get a tax credit. Then instead of paying 1,000 of taxes, I pay 500, 600. And what happens is that these firms, they actually sell fraud schemes. And these fraud schemes are comprised of everything: software programs, certification by professionals linked to them, And when they do this, they get a fee back. And we realize sometimes the fee is simply a share of the sum which was gained by the other companies. And often, and they are fake programs, fake schemes, because often the companies, they do not spend €1 over technology or machinery. They just say that we had a search and development program. We use our workforce for a lot of time. Then, instead of paying 1,000 taxes, they pay less because they say we compensate. And it's a huge scheme we are finding in our investigations. This actually, it's not a company. It's the firms who's looking for the company to commit a crime.
Thank you. Calogero?
Okay, so I think that I want to go back a bit to the big firm behavior, because I think we have to distinguish the criminal behavior that, of course, in this case is much more difficult to identify. When we have to deal with Amazon or Apple or Facebook or Google or similar, of course, it's very, very complicated to identify a criminal behavior, to identify the responsible and so on. But we have also to think about how they tend to avoid the payment of tax. I want to call to your attention, for example, just a few days ago, the General Attorney of the European Court of Justice, in the famous case of Apple for not involving the payment of tax in Ireland, just required to the court a new decision, a new ruling on the evasion, let's say, of tax payment for 14.3 billion of euros to the Ireland system, because in the interpretation of the state aid or not to the big company. So I think that we have, when we tend to identify the behavior of this kind of subjects, we have to think not only to the criminal side, but also to other kind of behavior that can lead to the same conclusion, the same outcome, but with a different modus operandi. This is a very interesting opinion. If you want, I can share with you somewhere. Because it's very motivated also on how the previous General Court of European Justice that was issued in 2020 was undertaking some legal errors and wrong legal assessment on these topics.
Yes, thank you for that. Yeah, and if you have something you want to share and can put it in, we can get it out there. And before, Simon, I turn to you, Gianfranco, I actually wanted to come back to you because I just wanted to clarify something that you were saying. I was very curious when you mentioned the firms looking for taxpayer clients, right? What kind of firms are you sort of seeing engage in that?
Basically, there are legal firms. I'm not speaking about big firms, based on my investigation, are local firms where you can find together lawyers, accountants, engineers, because usually in this kind of schemes, you need an engineer to say that to assess and certify that the project was real and the project was made true. And it's not true. Actually, it's not true. So they have to have someone, a technical one, to sign and say that. And so that's what we call it società di servizi, di consulenze, services. I don't know the right translation. Basically, the thing is, they're not one accountant, just as accountant, because you need different professionals in this kind of scheme.
Thank you very much for that. Simon?
Yeah, I mean, firstly, very much agree with Giancarlo there. Those sort of, we saw lots of those sort of schemes at one point. Some of them genuinely attempts to pay less tax, by some sort of avoidance scheme that we would typically tackle by taking to tribunals or courts to dispute. But some of them were just lies. And a great example of the sort of thing that was mentioned there was a case where you could get a tax relief for environmental research, and this whole scheme was based upon investing lots and lots of money in I think Amazonian rainforest for sort of all sorts of research, and this was certified by an eminent professor who had an OBE in the UK and all that, and it was all rubbish. None of the money was spent on that. It all went off to fund Dubai properties and Swiss bank accounts and all that. Now those guys ended up getting 7, 8, 9 years in jail. But the reason I put my hand up on it, I did want to just quickly, if I can, mention I think a couple of cases that are recent and are very interesting in the context of what we've just been talking about and some of the points that others have made. Interestingly, both of them are examples of collaboration between tax administrations that Rich Webber referred to earlier. So the first you might have seen in the papers recently, the conviction of Bernie Ecclestone, the Formula One mogul, recently, for probably the biggest individual tax case ever in the UK. He's ended up paying something like £700 million to HMRC, and over half of that was a penalty. He paid a penalty of 200% of the tax. So, and that was something that involved trusts in Singapore. So the sort of thing that would have to have been set up by some sort of professional advisor. But very interesting in that case, that the tactic of the prosecutors and of HMRC was not to try to prove the overall tax fraud, which would have been very complex. Would have involved a very lengthy trial, and for a man of 92 may never have, or 91, whatever it is, may never have got there. They simply proved a lie. They proved that Ecclestone had lied to HMRC in an earlier investigation when he said, I have no interest in any trusts. So I think that's a really interesting tactic, massive tax fraud, and very, very interesting case, and involving the UK collaborating with other tax authorities. The other one is something that was a series of coordinated investigations by a group of tax authorities we called the J5, that was the UK, Australia, America, the Netherlands, Canada, into a bank called Euro-Pacific Bank. So this bank is based in Puerto Rico. That's relevant because it's outside of the automatic exchange of information. And we suspected that bank of facilitating tax evasion and money laundering on a global scale. So a series of coordinated investigations, arrests, searches, subpoenas, sharing of intelligence, and as a sort of byproduct of that, if you like, that bank is now out of business. The regulator in Puerto Rico that the tax administration shared intelligence with had a good look at it and put it out of business. So I think really interesting examples of, in that situation, it was effectively the bank, presumably had tax experts and accountants in there, but the bank that was facilitating or promoting. The other one, an example of a very wealthy individual who'd have been getting very personalized advice, and a good example of where that offshore scheme was unraveled, and shown to be wrong.
Thank you. Rudolph?
I have just a point to you don't really need to be part of the crime, and you're honest person or honest organization. I've had an example where I worked. We used Bermuda and had a company down there in Bermuda, and to make it an active company, what we did is that we redirected telephone calls from Cable and Wireless Bermuda to London, and we had email address in Bermuda, and that basically meant that's a physical presence. So not even a tax investigator or let's say a prosecutor would fly to Bermuda to see if that office really exists there, but he would call, and then he gets someone out of London answering, here is Bermuda, because they knew that we have to play the game of Bermuda. So the telecommunication as such, or even you can say IT companies who provide servers in offshore centers to show that there's a physical presence, of an organization, which basically is only a letterbox. It's very difficult, even not possible to find out, in my view. It's out of reach of prosecution, in my view, as well, because how do you get the evidence? That's the way how the operation is set up. That's just I wanted to bring in.
Great, thank you. I want to just, before we sort of leave focusing on the entities themselves, just raise a question about corporate compliance programs in preventing professionals from engaging in being involved in tax crime. Just curious to what extent you've seen that play out. Is it effective? What role does it have in sort of curbing professionals' participation in tax crimes? Vasilios?
Yes, I would be quite short on that, because in fact, the whole corporate compliance mentality is currently being evolved in Greece. So I think that it will help, especially through creating of internal whistleblowing channels to the companies themselves. This is something that we have seen happening lately, mainly in insurance companies. But these are companies that have 50 or more employees. So in bigger companies, I think this corporate compliance mentality will help, but we still need the mentality.
Thank you. Laureen?
Yeah, I have to come back to the larger scale structural issues. It's not accidental that tax avoidance and evasion, and obviously Switzerland is an exception, but the explosion of tax evasion in the last 40 years, corporate compliance programs are part of a culture, and it's a neoliberal culture of globalization that actually celebrates wealth, and there's a well-orchestrated libertarian contempt for taxes for the public sector in general. And this has been, this is not accidental, this has been created. It isn't, I mean, people just have to think back to the Trump versus Clinton debate in 2016, when Clinton was saying to Trump, oh, well, you won't release your taxes. That's because you're evading the taxes. And she said, that means you're a crook. And he said, no, that means I'm smart. And that is the culture that you are up against when you are trying to, it's the same with corporate social responsibility programs. And there's a lot of literature showing how they are great as long as they don't upset the bottom line. So my last point there is that we know there's lots of literature showing that MBA programs, students in Master of Business Administration programs, get progressively less ethical with each year in the program. So you're not just up against a series of difficult laws. You're up against a neoliberal globalized structure, and that's is the setting for all of the explosiveness, I think, of tax evasion.
Thank you. Roel? Oh, you're on mute.
Yes, I agree with you, Diane, that compliance programs really help in, let's say, making professionals aware that they should not get involved in fraudulent schemes. When we look at the cases, the new cases brought to us, the Dutch prosecution office, we see hardly any big firms involved in the cases. In the past, it was really different. And it's not only because of this compliance programs, but also because regulations around it are much more strict than in the past. The professional associations in the Netherlands have more strict rules. In case you get a penalty, for instance, from the tax department, you have to make a notice to the professional association, which will make an inquiry itself into the acts you did. So
that's, I think, starts to be effective. The fact that compliance is more and more strict, and that also what we see, and also when I talk to young people, the new young professionals are less inclined in, let's say, advising their clients to the edge, but they are more looking to compliance. They're more looking to, let's say, a fair share. And okay, we're not living in the ideal world yet. I'm not naive, but we see, let's say, a change in the type of cases. Not now, it's more the real rough fraud what we get. Let's say the VAT carousels and that sort of stuff. And you don't need a professional anymore to step into a carousel. You can find on the internet all the stuff you need to start a carousel if you like. So yes, I think it starts to work.
Thank you. Bernd?
Yeah, I think the biggest benefit of the cooperative compliance programs lies in the fact that it brings a bit of transparency to the tax planning strategies of the multinational or big companies. And that's something that that's also been brought up to this responsibility of the board of the company. So I think the potential there is quite huge. Within Africa, what we've seen is there aren't many of these programs running yet because of obvious capacity issues. But we've seen in South Africa, in Zambia, some of those countries have started to implement these programs. And where you have limited resources within a tax administration or expertise, this is a very good tool to enable you to ask questions to the multinational entity. And they are basically compelled, once they're in that relationship, to be as open and as honest as possible. So I think the overall objectives of the cooperative compliance program certainly is something. Thank you.
Thank you. You know, I just wanted to take one moment just briefly to see if any of you had additional thoughts you wanted to raise on the role of technology, either as enabling or limiting the involvement of professionals in tax crime. So early on, Matej, you had mentioned technology playing a role, but I just wanted to see if anybody else had any observations about where you see technology as part of that conversation today. Manuele?
Yeah, well, I mean, what we've seen is just the speed at which transactions happen and money flows, and I think it's self-evident for all professionals like yourselves to how difficult it is to grasp the speed at which movements between companies can happen, between bank accounts can happen, between entities that appear and disappear happen, and the sheer speed of money flowing and passing hands, I would assume makes it extremely difficult for someone to backtrack where it originated from. And I think in all this discussion, I was wondering why, apart from Simon, who mentioned it briefly when he talked about the Puerto Rico bank, but why did we leave bankers out of the picture? Why were banks not included in the list of professionals who supply services to tax avoidance? Because ultimately, any company avoiding taxes needs a bank to do that. So how come they were suddenly not included in our list of professionals who, you know, partake in the tax avoidance systems and obviously in the money laundering system when we delve into the dark side of things?
Thank you. And we may pick up on some of that in our second part this afternoon as well. I want to take a moment and focus our attention on the challenges of sort of detecting, investigating, and prosecuting tax crimes. And so I might sort of frame that in a couple of pieces. You know, what do we recognize or observe as common signs or red flags that professionals or firms are facilitating or helping to facilitate tax crimes? And what have you found to be investigative techniques that might be particularly effective in both detecting such activity and then gathering evidence against tax professionals involved in criminal conduct. We're seeing phone tapping, audio surveillance, undercover. And really, how does that come together? What are the challenges if you're a prosecutor trying to build a case? So thinking about signs, detection, and then ultimately prosecution. Sergio?
Thank you. Again, one of the biggest issue for us is the detection of tax offenses in general, because there are, of course, investigation performed by tax administrations, tax agencies, and sometimes some suspicious activity reports that can lead us to some findings, but to my views, it's always hard to cover a wider area of crimes that are clearly being committed also in tax crimes. As for Italian system, so far we cannot rely so much upon a good whistleblowing system, especially in tax crimes, in white collar crimes, I would say. We are trying to manage with a new law and a new system, but we are very, very far from an effective system of transferring of information from the internal, the companies of the situation, which would be the very important key to get in.
Thank you. Mate?
Thank you. I wanted to point to this website, this journalistic website in Germany called Corrective, and how they discovered the Comex fraud case 4 or 5 years ago using undercover journalistic methods, which, the fake shake or something similar to that, where they approached an investment broker in London, pretending to be investors looking for a good deal and, looking to make some money. And the broker was being secretly filmed, and the broker proposed to them and explained to them how the tax system in Europe can be exploited to make loads of money easily out of dividends and capital markets and all of that. And after the story went out, prosecutions, a few years after the story went out, prosecutions began, and they haven't stopped. So Denmark, Germany is really going at it. I think France as well. Lots and lots of European countries are still prosecuting people for this massive sort of carnival of fraud, tax fraud, thanks to a bunch of journalists going undercover.
Thank you. Enrique?
Yeah, sometimes the tax legislation is so complex and confusing that even the tax administration is not capable of identifying some crime, or maybe the prosecutors. So I have seen cases that my colleagues, we are not so familiar with tax law, just don't see it, a crime there, and therefore the investigation was not started. So that, for me, is the first step. And taking the example from the Comex case that Mate just said it, if I'm not mistaken, the Comex was discovered years back, but the case didn't follow through. I think they gave the information to the German prosecutors and nothing happened. And then maybe 6 or 7 years later, someone looked to that again, and then the investigations really started. So, and I've been saying that to foster my first point. Sometimes you need specialization, you need people that really know tax law to do criminal tax law. So it's just not necessary to know criminal law. If you don't know tax law, you're not going to do a really good job at prosecuting those offenses.
Thank you. Kalahero?
Yes, I think that if we are talking about investigating a big tax crime from a prosecutor point of view, we need the real tool, effective tools. For example, here in Italy, we have the luck that we can use a lot on these directly wiretappings, interceptions, telematic interception, or live interception, especially if we are able to build up a criminal association aimed at tax fraud, at tax crime, or similar. But without, on the other side, as Sergio said, we don't have a good system of whistleblowing, so this is one of the gap of the system. But I think that the prosecutor need, as the last colleague said, first the tools, second people who really understand tax law together with criminal law. I don't agree on the point that you don't need exactly to understand the criminal law, because if you want to get real evidence, effective evidence, and evidence that can lead to conviction, you need people that on one side know, of course, tax law, but on the other side they have to know how to get the evidence that can show the judge the commission of the crime. And the third point is the specialization that must be not only on the prosecutor side, but also on the judge side. To be honest, in many cases, I realized that the specialization that we have may be on the law enforcement agency side, on the prosecutor side, on the people who support with the prosecutor area, is not on the judge side. I think we need also training, formation, experience for judges to understand and to figure out how a tax crime case is different than that kind of crime of a case.
Thank you. Simon?
Yeah, I mean, I very much agree with the last two contributors there. The majority of tax evasion is actually quite small. You know, most tax evaders are small businesses; they're quite small, and most tax authorities can deal with that with, you know, civil tax investigations and do that very well. But the bigger stuff, the more serious stuff, the more complex stuff, needs much more than that. It needs some of the methods that have just been mentioned there. And not all tax administrations have those powers, and not all tax administrations have that capability. There's been lots of work by the OECD and others over recent years to try and build that around the world. And certainly in HMRC, I was very lucky. I had a team of 5,000 people who were dedicated to tackling serious tax fraud, and that involved both criminal and civil investigators. In terms of how, you know, the detection, it's primarily about intelligence for the most serious tax crime. Yes, data can take you so far with lots of things, but it's usually hard intelligence that's the most useful in this area. So that could be suspicious activity reports from banks or other professionals. It could be the exchange of information, exchange of intelligence with other countries, other jurisdictions, or police forces, or, you know, other enforcement organizations. It could be whistleblowers. It could be individual whistleblowers who come to tax administration either because they have a grievance against an individual or a company, or it might be they're looking for a reward from the tax administration, or it could be the sort of big leaks we've seen, like the Panama Papers and some of those big journalistic things. It could be proactive intelligence gathering by a tax administration. You mentioned wiretaps, the use of undercover. Obviously, that's very, in most countries, that'll be very regulated, and tax administrations absolutely have to obey the letter of the law. So some other people might not do other types of things, but, you know, if you're a tax administration, you're working like a police authority or whatever, and have to do that properly. So that's the type of things that will lead to the detection of serious tax evasion.
Thank you. Sasha?
Yeah, hopefully it works now. Now in the Netherlands, we are investigating the cum-ex as well, and actually I'm working on it, and Roel as well. And there are various reasons why it took so long. one of the cases is that you first ask the tax administration to do all the research before it's taken to a criminal case. And here I have to admit that the journalist did a lot of good work, which we can use as well. And what's also interesting to mention, and that's also already in the papers, we have a joint investigation team with other countries. So we share a lot of information that we get. So if one country has whistleblowers, we can use it. While in the Netherlands, it's for example, difficult to, or we don't have a good system of whistleblowing. But working together makes it much easier to get all the information you need. So I don't want to say too much about it because it's still under investigation. But I think the big advantage, and I hope that we will see that in more and more cases where there's a global tax fraud, that we work together, because that's most important for it.
Thank you. Irina.
Yes, I would just like to say that in my country, we don't have many cases of whistleblowing, but regarding the so-called red alerts or red flags, I would say that one of them would be a sharp increase in income in legal entities, and also disappropriation of assets of owners of that legal entities. So we have an independent sector for financial investigations that's operating within the tax administration of Ministry of Finance in my country, that does a really good job detecting those red alerts. But from a prosecutor's point of view, I can say that we often conduct special investigative measures like surveillance or tapping or technical recordings of telephone conversations, secret tracking of persons and such. So that's it. Thank you.
Thank you. Massimiliano?
Building on what Calogero just said, I would like to give food for thought, maybe from prosecutors like Irena or Sergio or Calogero. Would they envisage as useful to create a specialized section of prosecution office, a specialized section of judges for this type of crimes?
Thank you. Hassan?
Yeah, can you hear me?
Yes.
Yeah. Okay. I wanted to build on what Sasha has said. She was telling about the role of whistleblowers. So my observation is, in such case, there is a law that is named Magnitsky Act or legislation that has been implemented in multiple jurisdictions, and that act has been named after Sergei Magnitsky, who was a tax advisor and who was a whistleblower as well. He uncovered a large scale tax fraud scheme, and later he was systematically tortured, and we know what happened to him. He was killed in a big country's prison. So my point is, when Sergei Magnitsky acted as a whistleblower and shared some information across the borders, so his safety or security was not ensured. If while we focus on the information sharing across jurisdictions, it is also critical to ensure the security of the whistleblower and ensure some rewards so that such information sharing can be more meaningful in the upcoming days. That's me.
Thank you. Kalahera?
Yes, just to respond to what Massimiliano asked a few minutes ago. I absolutely agree that you need in these topics much more than in others in this kind of investigation the specialization. Usually, at least in Italy, we have a specialization on the prosecutor side. I think that all the big prosecutor office have a department or a group specialized on financial crimes or tax crime or economic crimes in general terms. We have also specialization on the law enforcement agency side. We have here the financial police, the so-called Guardia di Finanza, that I think is one of the most advanced financial police in Europe for sure. And in fact, for example, now the office I'm working on, the European Public Prosecutor Office, is also specialized on on financial crimes and on tax crime, was decided to create an academy that is called EPPO Academy for the training of law enforcement agencies of the 22 member states that joined EPPO. That is exactly at the Academy of the Guardia di Finanza in Italy. On the other side, usually we don't have the specialization on the judicial side, the judge side. I don't think, I'm sure we don't have in Palermo, we don't have where I worked for many years, but I think in many other court tribunal we don't have a specialized sections of judge that deal only with tax crime or with financial crimes. Maybe Sergio, that works in Milano, can add something more about that. But by the way, it's not something that is very common in many countries. I'm quite sure about that.
Sergio, thank you for Calahero. Sergio?
Yes, I confirm it. To my view, specialization and the expertise in these topics is crucial for a good outcome of the law enforcement strategies. As Calogero said, we had a good specialization on the prosecutorial side and on the investigative side, but not always on the judicial side. In Milan, which is a big office and for his tradition has always dealt with criminal, economic criminal activities. Also, the courts are specialized and they are very good, and this is really a plus in carrying out such cases, in putting such cases before the court. Of course, both us as prosecutors and also the judges, they can rely on the help, on the support of experts as consultants. They are allowed to appoint experts to have something in a much more understandable way, but it needs for sure a good basis of knowledge of such topics. Otherwise, your counterparties, they are very good in drawing the picture in the way they like. They are often better than us because they do it as it's their job. They are very good in their job, and we have to face all these challenges to tackle them. So we must study. Judges are supposed to study as well, not only relying on consultants' expertise.
Thank you. I had Irina next.
I can say that we have a similar situation like with Calogero and Sergio. We have a specialized financial police. Also in our state attorney's office, we have a department for financial crimes, but unfortunately, judges are not specialized. So they are leading the cases regarding the general crime as well as the economic or financial crime.
Thank you. Barbara.
Yes, thank you. I completely agree with my colleagues. The alluvial production of legislation in such a technical sector also require a necessary specialization of the judges, not only of the prosecutor or the investigators, generally speaking. In the big courts like Milan, Naples too, there are semi-specialized sections. So, for example, I am in the Court of Appeal. There is one section that is complying with financial investigations. And in our Supreme Court of Cassation, there is a specialized section. But the problem for the judges in Italy, at least in my opinion, is the training of the judges, because on the contrary of public prosecutor and all the investigator and the inquiry sector that is pushed to study, is something that for the judges depends on themselves. And I think there it's very important, and it's also for this purpose that I promote this kind of training section, just to let them be more confident with all the issues that the tax avoidance or evasion arises. Thank you.
Thank you. Royal?
Yes, I agree that also judges should be specialized. And well, in the Netherlands, we see more and more in tax fraud cases that the criminal courts ask a colleague from the tax court to join the chamber who deals with a tax fraud case. And that's, I think, very productive, because then you have, let's say, the knowledge of the criminal judges together with the knowledge of the tax judge to deal with such complicated case. So there is a solution for it.
So I just wanted to, Enrique, have you pop in first?
Yeah, I would just like to say a little specific data about Brazil that is really unusual. So I think I need to share here because of ruling of our Constitutional Court. If a tax tribunal court and administrative court says that there is no tax evasion, we cannot try it in a criminal court, and the tax tribunal should assess that beforehand, or before we even start the investigation. So and the problem is that sometimes this process, this administrative process, takes 15-20 years. So how should I start an investigation 20 years after the fact? That is a big problem that we have here. We have some ways of bypassing that, but we are in murky waters, and we cannot really say that those prosecutions will have fruition.
Thank you very much. I had been planning to ask you all about sort of your recommendations, both to prevent professionals being involved in tax crimes, as well as how to sort of facilitate and enhance the prosecution. But honestly, you've wrapped that into all of your answers. So I just want to quickly run through it. Highlighted whistleblowing, the degree of tax experience of both prosecutors and judges and courts, and different ways that might be enhanced, whether it's through direct training, special technical expertise that can be called upon, specialized enforcement units or courts. International cooperation was mentioned, as well as information exchange. And then sort of relatedly, whistleblowing transparency. So thank you for weaving that all in. And what I would like to do now is close out this first part. We'll take a 10-minute break. We'll return, and then we will go to our second part.